Okay, I'll make a start then. So good afternoon, my name is Reagan. If you are struggling to hear me, just let me know in the chat, but I'm assuming, unless you say otherwise, that everyone can hear me okay, because you can see my mouth moving. So if you can't hear me, then this is your chance to say. Last week, was it last week? No, I think it was about a month ago, actually. We did some work and discussion around non-accidental injuries, and we covered the overview of the law in that area. Now, of course, there are more specific cases that are relevant depending on the type of injury, but the overview largely covered the majority of the first approach to be taken and the majority of the general guidance in this area as to how the court looks at these matters. This time around, what we're going to look at really are more practical issues, and a lot of this session will be around discussing what I would see as a sort of good practice, making sure things are done properly, and really it largely comes down from things that I'm aware of through experience and through interaction and consultations with other counsel. But I thought it would be helpful for us to collate it all in terms of this session and to put it in one place so that we can try to get through it all together and we know where we stand, and there is more of a consistent approach moving forward. So what we're going to look at, if you all get your handout out, last time I forgot to discuss the law on interveners, so I shall make sure I cover this for you this time, so apologies. Then we're going to look at really what social care should be doing when these issues arise, when non-accidental injuries or possibly inflicted injuries arise. I am not going to cover what you do in terms of Section 47, investigations, liaising with the police, all of those matters. I think I'd be teaching social workers to suck eggs if I do that. They know what to do. But what I am going to cover is the thinking and the reasoning prior to going to court. And then once you're in court, what is expected of you and what kind of factors you need to consider. I will also give some very brief advice and guidance to any solicitors on the line of how we should approach these cases from a legal perspective and what I think is good practice in getting the cases where they need to be. And then I do want to spend 5 minutes at the end talking about the term non-accidental injuries. I'll come back to that in a moment. So, reminder of what we did last time. We covered the law, we covered the standard of proof, i.e. this is the local authority's case to prove. We covered Re-A and the importance of gathering Children Act statements and primary evidence to support what we say and not just relying on hearsay evidence. We covered the approach that the courts take to identifying perpetrators, i.e. there must be some evidence to say that someone is in the pool. That's the approach that is taken. The court has to look at whether or not it is reasonable that they are in the pool. And if they are, then of that list of people in the pool, whether they can identify the actual perpetrator. And if they can't, then of course those people are in the pool. And then we discussed as well expert evidence, the importance of it, how it is important as part of these cases, but it is not the be all and end all. And of course, everything has to be looked at in the round, which is why you get the cases where, if I call them the squeaky clean parents, the parents who aren't known to social care, can sometimes have an arguable case to say that they didn't injure the child, even if the medical evidence says that the injury is likely to have been inflicted. So let's turn firstly to the issue of interveners. You will all know that an intervener is like a party, but it's not a party. The court may join a non-party to proceedings, giving him full party status or a right to intervene. And I suppose what you want to know when you look at this is, when will I need an intervener? Why would I need someone else to come into the proceedings? Should they be given full party status or should they be given intervener status? So, for instance, a lot of us know that at times, for instance, a grandparent can come forward and wish to care for a child and place the child there, and we grant them full party status. So they see all the papers, they get representation, they are able to take part in the proceedings fully. Why is that different? Why do we do that for them and not interveners? Well, an intervener, I've written a few cases here, Re-S, Re-H. As a general rule, they tend to come on board really to defend themselves against something. So, for instance, if your typical intervener, I think, is your stepdad, isn't it? If your stepdad who's accused of hurting the child in some way and wants to defend himself against the allegations, and that is normally where we will intervene him into the proceedings to do just that, to deal with that very discrete issue of his role in his role, I suppose, because I said stepdad, in defending himself. Now, that doesn't mean that it can't be a stepmom or someone else, but that is typically where you see interveners coming in that sort of capacity. You can also have it where another child, for instance, has been accused of abusing a child, and you might need to bring that child in as an intervener, but that, of course, has its own complexities, and we have to be careful with that one. So I've given a few examples there of when it can come in. And when we would bring interveners in to play a discrete role in the proceedings, I think is probably the easiest way to describe it. But of course, when they are joined into the proceedings, we still have their right to a fair trial, which has to be absolutely respected. Now, I do pause here, though, because in fact, they don't get technically the same rights as guaranteed as part of the process in care proceedings or private law proceedings, as full parents do for full party parents. In fact, interveners don't get, for instance, the right to be present at every hearing, the right to cross-examine witnesses. We assume that they do, and we treat them just like other parties in many respects to these cases. But in fact, family procedure rules don't cover them for that. And if someone wished to object to them attending every hearing, if someone wished to object to them cross-examining certain witnesses, they are entitled to do that. And I think you should all be aware of that they don't have that automatic right, even though we treat them in that way. So I've given a few cases here of that. I've explained they have a right to fair trial, which always has to be balanced. When would it be appropriate then to have them? When they have a limited role to play, i.e. defending themselves, so your typical NAI case. But also, there might be other times where you want to make someone an intervener rather than a party. And a very good example of that is where you don't want them to have full papers, because of course, I don't know if all of you know this, but to stop a full party having access to certain papers and proceedings, it's a high court, well, it's not a high court decision. You need a high court judge in the family court to sanction that. So you have your issues about Section 9 judges and dealing with that issue. Whereas actually to limit an intervener to have papers, because their interveners are not full parties, you can do that by any level of judge. So district judge, circuit judge could do that. I'm just checking the chat function just to make sure that everyone understood that when I've explained it, because I think that is important before I move on. So just to repeat, full party status, it's an application to withhold information from a party to proceedings. That has to be dealt with by someone of a high court judge level. Interveners, you can withhold certain papers for them. And for instance, your stepdad is very good for this, because you might not want him to see everything in the papers relating to final decisions, relating to dad's vulnerabilities. Dad might object to that, in which case grant him intervener status and you can limit certain papers easier. And actually, if he's got a limited role to play, that is the ideal way of doing it. Does anyone have any questions on that before I move on? If a yes or a no in the chat box could be said, that'd be great. Just by anyone. No. Thank you, Jade. Thank you for being brave. So that is another scenario that you have to think about. What I've written there, though, as well, is remember when the child objects to their information, remember Gillick competence. Now, this, I think, is something that gets overlooked a lot in these proceedings, because you have the child's representative and the guardian, and they will just take instructions and go, yes, they should be given this. Actually, when a child is Gillick competent, and I think we all know that we can assume safely that when they're about 13, 14, we need to start thinking about that, probably even younger. That actually, when it comes to sharing that child's information with a non-party, with a stepdad, with a grandmother, with whoever, they should be consulted on that decision. The same way the representative from mum and dad will ask them, are you happy for that person to have your information? That Gillick competent child should be asked that question. And 9 times out of 10, in my experience, the child's representative will forget that because it will be at a case management hearing where actually they just think this is a case management decision, just take the guardian's instructions and go. Actually, the decision on what information is to be shared with interveners and non-parties is something that if the child is Gillick competent, they should be consulted about. Of course, the representative should give them advice on that. You have a similar issue when, and I'll go off tangent a little bit here, when you have, for instance, psychological assessment of a child who is 13 and 14, and they must be advised, or it is prudent for their representative to advise them, A, that they'll have to participate in this, but B, that is a report that stays on their file for life. And they need to have some legal advice, if they're legally competent, around the implications of that and whether or not that is something that needs to be pursued on their behalf or objected to on their behalf. Now, I flag that because even though we don't represent the child, if we are for local authorities, to make sure that your cases are safe, they're not subject to appeal, there's no backlash anywhere, you need to be flagging that to the child's representative earlier rather than later, because they do forget. In almost all of my cases, I've never had someone say to me, oh, I've consulted the child on this. I've had to remind them and say, please, can you go out and do that before the next hearing? And so I do flag that for you to think about, because there are implications if it's not done and it becomes an issue later on, and you just want to dot all your I's and cross all your T's on that. When a parent or other party may object to information being shared, and when you need to limit the bundle given to them for any other reason. I think that those are, broadly speaking, your reasons why you might choose to make someone an intervener. Okay, so that's the bit I missed off from last week's session. I managed to cover it in 10 minutes, so I'm doing good time. Let's turn now to what this week's meant to cover, which isn't so much the law, but it's more just the practice. When social care gets involved with a suspected non-accidental injury, and what needs to be done. Now, we know that when they get such a report, of course, they go and they get the child protection medicals, they launch their Section 47 investigations. I'm not going to say about that because they know what to do about that. But fundamentally, what tends to happen is legal then step in. And you can all tell me, because I think the majority of you work for local authorities, you can all then tell me about this. But legal steps in to give some advice on this. And if legal doesn't step in, and I've got social workers on the line, please go to legal on this. As to what should happen at that stage. And we get a lot of situations where the social workers may agree a Section 20 with the family, or may agree, or I don't want to say coerce the family, but influence the family to move the child to live with grandparents while they look into this. Do not forget that Section 20 is a temporary arrangement. And if you need to put that in place, you need to be thinking of, how long is that going to be in place for? And if actually it's going to be in place for, say, more than a month, you need to be looking at issuing these proceedings. I say more than a month, roughly. Of course, there are situations that vary and need shorter and longer timescales. The second thing is, and I do think social workers sometimes forget this, and we need to be reminding them as legal as well, is the phrase private family arrangement is becoming too prominent, and worryingly so. If social care have even suggested that, oh, baby, let's pick a baby's name, I don't know, baby, oh, Mandy must go and live with granny whilst we investigate this. If they even suggest that by saying, can Mandy go and stay there for a bit while we look into it? That is not a private family arrangement, chances are. And there is an argument to say that they have influenced the family and pushed that baby in that direction because the family will have felt the pressure from social care to do that. It will, in essence, be a placement that we have organised, possibly classed as a foster placement, so we may have to pay fostering allowance for it, backdated. And in those situations, again, if that is what we've had to do to safeguard this child, it is not a private family arrangement. We need to be looking to go to court to get that properly sanctioned and endorsed. And I flag that, again, for the social workers and the solicitors on the line, when you get these cases and they say, oh, we can put the child here, if it is a Section 20 or an arrangement that social workers have had a hand in organising, you need to be thinking about, can we put the child back? Is it safe to do so? And if it isn't safe to do so, go to court to get an interim care order to endorse that, or go to court to get an interim child arrangement order to endorse that. Don't just leave it as it is, because then you will be criticised. Which links on to my next point. Do we need clarity to further risk assess? And what I mean by that is, it can sometimes be the kind of injury where it's a minor thing. Someone's accepted, look, I did this, I didn't mean to do it. Work can be done with them and we can rehabilitate and the family will be fine. Or it can be a major thing. So, for instance, a broken femur, where you really do need to know if someone's done that, no one's owning up, before you can risk assess and decide what to do in that child's life. Do not manage that under PLO. I know we've had the new public working group guidance come out. I know that they're aiming to do things more under PLO, but in that situation, you need a decision as to whether or not that injury has been inflicted on that child, and if so, by whom or who is in the pool. You cannot manage that under PLO. And the longer you drag that out, the weaker your evidence base will get, and the more you will be open for criticism by separating this family, obstructing the family unit, interfering with their right to family life when you shouldn't be doing that. And maybe for the solicitors on the line, I am teaching you to suck eggs, and I apologise that this is more for social care that's on the line, so you understand that that is an important thing you need to think about. And of course, I've written, is there another reason why issuing proceedings might be appropriate? And I'll leave you guys to think about that one. You've seen there an exclamation mark, which is not my favourite grammatical tool, but yet it's being used. If yes, then issue. There are cases, I'll say again, where you can manage under PLO. If you need to know if something's happening to a child to risk assess, if you have obstructed a family until you get the answer to that, take it to court, get it properly endorsed. Don't forget, I've lost my train of thought. There was something really important. That's it. Don't forget as well, this is a horror story that I have. I was for a dad on a case maybe 2 or 3 years ago, and the social work team had made all these decisions about he's done this, this, and this, and done this negative assessment. And when she got in the witness box, the team manager, I said to her, did you make the decision on these? She said, yeah, I gave guidance to my social workers that they need to work on this basis. And I said to her, well, how did you know? How do you know he's done all these harmful things to the children? And she turned to me and she went, well, it's the balance of probabilities, isn't it? And I just thought, it is the balance of probabilities for the judge to apply, not you. And just, I think as well, when these issues come up, social care have to be careful with that. They may look at the evidence and say, no, we think he's done it, so we need to risk assess on this basis. Or no, they haven't done it, so we're not going to do it. That is not a decision for you to take. It is not. And if you do take that decision and you interfere with family life, you will have a claim on your hand. If you take that decision and you rehabilitate a child and then something else happens to that child later on, you will have a claim on your hand. The best way to protect the authority is to go to court, get a determination by the judge. I have a case at the moment, and I don't know if the solicitor's on the line, if she'll know which one I'm talking about, where we have a mother who, the child has been injured in a foster placement, a mother and baby foster placement. And so we have the case where this mother might be able to care for this child, but we don't know if mom has done this, or if the foster parents have, or if no one's done it. And my advice had to be, you need to go to court to get clarity on that. Even if you're not pointing the finger at mom, you need the judge to give a determination that mom hasn't done this before you can assess her further. And that is what I would say to authorities is, yes, we are the applicant and we have been derogatorily referred to as the prosecutor in these matters. And I don't like that expression, but you do get it. But fundamentally, there will be those cases where you need to put in position statements saying, please can we have a fact-finding hearing on this? We're not saying that we know who definitely does it, but we're saying the court needs to determine it. You will still have to plead threshold. You will still have to pursue it. But then I think taking that approach is more helpful to you, because if and many of you will know this, if you don't get that finding, you can see a parent's rep going, we want an ISW, that social worker was gung-ho against us, they definitely believe we injured that child when we clearly didn't. And actually, I think you best protect your social workers sometimes when these things happen, to say, we just don't know, and we just need the court to decide before we can assess further, before we can rehabilitate, before we can look at plans. So bear that in mind, in terms of why we might need to issue, and be careful of what decisions social care are making behind the scenes. Okay, so what to do when proceedings have been issued then? Well, before we go to the door of the court, I just want to talk to you about the kind of issues that come up right at the start. When you get there, there's lots of this, oh, do we really need removal? And before you go to the door to the court, I just think social care need to think very carefully about, what is the injury here? What non-accidental injuries there are? What is therefore the risk? And how could it possibly be safeguarded internally? And I know you're all going to say to me, Regan, we know that. But I do think that in these types of cases, in my experience, we tend to, or the social work team can get caught up, perhaps understandably, on someone seriously injured this child, we need to get this child out. The court doesn't look at it like that. And I have quite a few cases where we've gone for interim removal and it's turned out an auntie could care. An auntie could move into the family home and the parents could keep caring under 24/7 supervision. And that has been deemed the appropriate path to take. And I think we have to bear that in mind as well. If you have your cases with drug misuse and domestic abuse, that may not be right. But I think one of the reasons I wanted to put these sessions on, especially on non-accidental injuries, is because these types of cases become a pain in the backside when we have our squeaky clean parents and we don't know what's gone wrong there. And they're the ones that I want to say we go after, but they're the ones we need to investigate properly. In those cases, I think the authority does better by taking a measured approach, looking at, can a family member move into the home? Or, as I have one of my cases at the moment, there's a wider family network of uncle, aunts, nieces, nephews, grandparents, I don't know, their donkeys, their horses, God knows. And every person, possibly even the donkey, plays a role in supervising this family in the home for certain periods. So auntie moves in Mondays, say from 6 o'clock till Tuesday 6 o'clock, then another auntie comes in Tuesday 6 o'clock to Wednesday 6 o'clock, and they just rotate it in the family network, whereby someone is there supervising the care of the parents 24/7 and not leaving them alone with this infant. That was endorsed by the court. I was deemed appropriate, and actually I have to say it was good social working on the ground that they came up with that plan, because they held a family group conference very quickly. They made sure they got this arrangement in place. They put it in a safety plan and outlined it for the court. And would you believe, even though we have a very serious injury in an infant, they have an ISO. The judge didn't feel the need to make the ICO, A, because the parents don't have anything on the file of concern, and B, because the family network could support it. So I just flag this for legal. Well, I flag it for social care to think about when they come to court, and I flag it for legal to troubleshoot when you get those initial statements, to go back and say, have you looked at a family arrangement that can work? Have you looked at if someone could move in? The second, quite often, family don't want to step up until things get serious and the matter is before the court. Yeah, you might be right about that, Jade. I mean, there will be cases where you're still going to have to do it on the door of the court. But I've also come across in my time doing this cases where the social workers just don't ask the questions, or haven't thought holistically, if I can use that word, about the support that can be there and the supervision that can be there. So it's always worth asking the question, I think. And even if the answer is no, it's no. But then you have your answer when you go to the judge. The other issue is, can, say, mom, even if dad and mom can't, can mom move into the home of auntie with the baby? Can dad move into the home of uncle with the baby? Because that is another solution, is rather than caring in their own home, they could go with the person to another home. And I had a case last week where I had assumed that that question had been asked. But you should never assume anything, should you? It wasn't. And then the judge pointed it out and said, well, can't mom just move into grandparents' home? And I was there thinking, didn't actually ask that question. I assumed that that wouldn't work. But so I called the social worker, only to be told, oh yeah, granddad's always said that that was possible. And so my question, well, why didn't we do that? Oh, it's because it's a serious injury. Yeah, just troubleshoot that, because that isn't necessarily, it doesn't follow that we will meet the legal test, and it doesn't follow that proper supervision can't safeguard that. Similarly, as to why you might need an ICO, an ISO might do it. Now, an ISO, I think, is trickier to get in those cases, but it's not impossible. If you put a robust safety package in place, then there is no reason why an ISO couldn't work, particularly for, say, newborn parents or parents who don't have a record of involvement with the police and social care. So I think I've done that. Now, the other thing I've written there is, if you do go for interim removal, think about the contact. So again, I've had a case, I think it was 3 or 4 years now, where I had a family and the children moved to live with the aunt when they discovered this injury. And the social care was still saying only 4 hours a day contact, which sounds, a high level, 4 hours a day. But the aunt lived down the street. And the question by the parents' reps was quite rightly asked, well, if we're trying to make things as normal as we can for the children in the interim, mom doesn't work. Why can't she just go every day? Why can't she go and help out with the morning routine? Why can't she be there during the day to cook for the children that aren't at school yet? Why can't she be there in the evening to put them to bed? In a normal family life setting, that sort of thing would happen anyway. And it wasn't something that I could rebut, because the aunt could be there to supervise. So I flagged this again because it's something to troubleshoot when we go to the door of court, is think about your contact plan, because this isn't a long-term plan. The interim one isn't a long-term one. You're not looking at maintenance contact. You're looking at, do you definitely need separation? Is the test met? And if it is, how much of the status quo can you maintain almost in terms of contact and the arrangements with the children? And again, that applies for a newborn, because of course they need to bond with their mother. And there is a stronger argument to say, I'm saying mother, I'm being a bit sexist here, aren't I? They need to bond with their parents. There is a stronger argument to say they should have extended periods of contact if someone can supervise. If it has to be professional supervision, well, you're restricted. But if there's a family member, then go for the extended contact. Don't limit arbitrarily. That's what I'll say. And remember, my final point there is, remember, older children can self-protect. Now, I had a case 5 years ago, maybe, where I had an infant, a newborn infant that had a serious injury, and I had a 12-year-old and a 13-year-old. We went for removal for all of those children. Did we get removal of the 12 and the 13-year-old? Of course not, because they were old enough to express their views. They'd never come to harm before. They were, they were regularly seen in school. They could self-protect. They did one-to-one work with the social worker and would be honest. She felt with them, with her. The risk level to them was different to the infant. And always think about that when you go for removal as well, that a newborn baby might need to be safeguarded because they can't speak, they're not being seen a lot more, they need all of their needs met. Older children are in a different bracket, and I know that Horonja Hillier in Leeds is keen on this one. She picks up on this one a lot and has said a lot. Remember, the risks to older children are different. So remember, all of this needs to be addressed in the initial sweat, and if you don't address it in the initial sweat because it's been issued urgently, the solicitors should all ask about all these things or relevant factors of this when they get to the door of court to make sure that the plans are good. Remember as well, during proceedings, to continue to review this situation. If you find a family member that could care, think about moving. If you find a family member that could supervise, think about extended contact. It can only be to the children's betterment. Okay, any questions on that section? I need a yes or a no. Jade, it might be you again. No, thank you, Jade. Jade's becoming my new best friend in this. She's helping me all the way through. Thank you, Ravina. Okay, so the next section of this is, can social workers help with the evidence? So we've talked about what happens at the door of court and the kind of things that you want to think about. Let's now talk about, once the proceedings are kicked off, what needs to happen. Now, we know that we're going to get medical experts appointed. We're going to have to do assessments, that sort of thing. What social work, how would social care help in presenting this case when we get to court to contest it, probably at the end or the middle, in the best way possible? Well, I've written for social workers, and I think if you as a solicitor get a kind of case like this, you want to send them this list instantly and say, look, remember these things. Because I think as well, if you flag it to them early at the initial hearing, they do better at doing it. I tend to find when I pick up NAIs, I do tend to get instructed on a lot of my cases from the very beginning, and then I see them through. And I always do this at the beginning. I always give advice at the first hearing that you need to do these sort of things, and it helps with the evidence when it comes in, makes our life a little easier. Clear notes of accounts. So when they spoke to the parents or the interveners or the grandparents, what they said to them at what time, and write it down. That might sound basic to you, but I think as solicitors, you will all agree with me, we get those cases where the statement will say, we know that mum has said this. Okay, when, to whom, more than once, what questions were asked of her, and you just don't get that information. Well, that is really key. That's so key to know where that's come from. So what I would say is remind social care to make notes in this order. When you spoke to someone, what they said, who spoke to them, and what questions were asked of them, and anything about their presentation is important as well. Because, for instance, I have a case that I might have to deal with baby shake, and I'm trying to get out of it, but I might have to deal with baby shake. In it, mum has said to one of the workers, I shook him. I didn't shake him too hard. But then she's denied ever saying that, and at one point said she was confused when she said it. The key bit of evidence there that I'm going to rely on is that at the time of saying it, she broke down and cried over the fact that she'd said it. And I'm going to be saying in court, well, that means that she wasn't confused. She knew fully well what she'd done. That's why she broke down and cried. Again, I would have had a more difficult case to put, not impossible, but more difficult, had the worker not made the note of she cried. So it is important that I think those 5 points are covered in all notes and counts made. The same applies when you get the initial sweat. Make sure that if they say things, social workers write passively quite a lot, and I don't know why they do that. Maybe they're trained to do that. But tell them, no, change your language into the active. It's not mother has said, it's or what do they say? I'm trying to think of an example of a really clear example of when they write something passively. I think you all know what I mean, don't you? mother has said blah. I think you need to know, I spoke to mother and she said this to me, kind of thing. Just a lot more direct in the language, so we know dates, times, who she said it to. That's also important for you as legal when you get it, because if you see that an account is taken by an officer or by another social worker or a family support worker, you need to go and get a Children Act statement from that person, because that is your primary evidence. Your Children Act statements are your primary evidence. I always think in my head, primary evidence is a Children Act statement from that person. Even if it's mentioned in someone else's statement, get it from that person, straight from the horse's mouth. And interestingly, and it's a legal point that you probably don't even need to know, but I'll share it anyway because I'm a loser and I know these things. ABE interviews are hearsay evidence. I don't know if anyone knew that, but because it's an out-of-court statement that goes to the contents of its truth, an ABE interview is technically hearsay evidence. But we argue in court to say it should be given the same weight as primary evidence. Like I said, you didn't need to know that, but I thought I'd share it. So that's your clear accounts. The second thing is follow up on leads. How many times have we had something said to us that we go, oh gosh, we didn't know about that. Had we known about that, we'd have got a statement from them. And I flagged that for the social workers on the line. If something has come out that might be concerning or help the case or go against the case, remember we have a duty to put both, good and bad, then we need to follow up on it. We need to call that person to speak to them, or we need to, if we're confused, raise it with legal so they can advise you. Let me give you a good example of that. I have a case at the moment with physical chastisement. And one of the children had said, oh, dad hit me during proceedings, and then told the social worker later, no, that isn't true, I made that up. I'm still pleading it, I'm still litigating it, see what happens, right? But I got the chronology through today from the social worker, the updating chronology. And in it, one of the other children has told the foster carer, our parents tell us that we need to lie to the social worker, and even if we said that we've been hit, to tell them later that we were being dishonest. Did I know that before? No. Are we weeks away from the final hearing? Yes. Would that have been helpful evidence when I'm going to pursue this child's allegation, or will it even be useful? Yes. So of course I said to them, go and get a statement from the foster carer. To be fair, my solicitor didn't know about that. That's why she didn't gather a statement before. But it's things like that I'm flagging. Raise them with legal. We need to follow up on leads. We need to get down the path of lines of inquiries earlier on. And it's useful as well, because in these types of cases of non-accidental injuries, it helps you to know when you might need to bring in interveners sooner as well. Prompt liaising with legal is important. I think I've explained why, so you can get advice about what you need to do. But remember that, and this is more for your new families, I've written there, all of this is especially important if it is a new family. And what I mean by new family is non-accidental injuries. You get a lot of family never known to social worker and baby's arm broken. Don't know how that happened. They never know how it happens, do they? But what we need from social workers and social care when those types of cases come in, I always say at a very early stage, get directed an assessment of the family. Now, some authorities call it a child and family assessment, single assessment, interim parenting assessment, child assessment. Some social workers are going to say to me, there's a difference between all of them. Quite frankly, the information you give me at the other end as the barrister, it's pretty much the same across those assessments. Well, the point is, get an assessment before the court of this family, their circumstances, their lifestyles, because what you're going to be doing whilst you do that, oh, someone's written something in the chat, just give me 2 seconds, guys, thanks. What you're going to be doing as part of that is evidence gathering and investigating. I've had cases where I've directed a child and family assessment, and it's been really useful to know that the account mum gave changed over 3 different sessions, only slightly, but did change. The account auntie gave when the social worker spoke to auntie was different from the account mum gave. Dad talked about arguments in the household, mum never did. Dad mentioned that mum would drink Prosecco excessively, mum says she doesn't drink at all. It might seem like little points, but they are really useful to counsel at the other end, or whoever will be the advocate, to know about these subtle discrepancies that could hit credibility and that could plug gaps in these things. So I always say, make sure you do some assessments so we have information on these new families. Remember your background checks, do your social care checks, do your police checks. And I will say again, just for the solicitors on the line, when you get plans coming through with family members either in the home or placement with family members, always remember to ask that question, because we sometimes assume that social care have done these checks. They don't always. And I've had cases where at door of court, it turns out there's something really concerning on the person's police record, and we were proposing to place there, and we just didn't know, and the Guardian found it, which of course is embarrassing for social care at that point. Remember to liaise with liaise with professionals on a multi-professional basis is what I've written. So if mum has a mental health worker, get something from them, find out what they were doing at the time, if they were visiting the home. It all seems like, oh, it's a lot. And it does need like all these evidence gatherings, following up on leads, doing background assessments. But when it comes to the door of court, what I tend to do, and I think a lot of counsel or advocates do, you try to create a chronology of events around about the time the child might have been injured, and building up to that. And all of these little bits of information do help to show if there is a pattern that is emerging in respect of mum's mental health, for instance, in respect of substance misuse in the home, in respect of stresses and strains on the home. And that is important, and that's why you gather it. So if you have these cases, make sure you look at that from a legal perspective and from a social worker's perspective to get everything you can. Okay, number 4, how to present the case. So from a legal perspective, I think I've covered most of this. We'll run over it again quickly. Primary evidence rule, remember your RE-A, get your Children Act statements. Consider early on if interveners need to come in. There I've written though, and whether it is proportionate. Now, to bring an intervener in, you kind of need some evidence in the papers to say that they could have caused the injury, if you're going after them on the basis of injuries, which is why we're here for the non-accidental side. So for instance, I've got a really interesting case at the moment, the one with the mum and the child being injured in the mum and baby unit, mother and baby foster placement. And I really want to go after the foster mum, but there is absolutely nothing on the papers to say that this woman was in the home at the time. And I have a feeling she was. I have a feeling that they're not being fully honest about that. And I worry that it'll come out in the hearing, and there will be, well, what do we do now? But the reality of it is, I cannot argue that she should be in the pool or the possible pool because the evidence doesn't support it. So you do need a bit of evidence to hang on everyone that you will say is a possible perpetrator to bring them in as an intervener. The second point to learn about proportionality, I think, is this, for instance, recently I have a case where we have a stepdad who's accused of physical chastisement, but him and mum, well, he's no longer with mum, and mum doesn't want to care for the kids. So what's the point in bringing him in? Because actually we have enough evidence, the fact that she's abandoned her kids, that means that their contact needs to be supervised because of the things she might say to them. She's not going to care for them, and this man's going to have no involvement in their lives again. So actually, do we need a 10-day fact find or composite final hearing to look at whether or not he's hurt these children? It doesn't impact on them. And in those circumstances, proportionality does play a part. So I flagged those issues to consider. And I know what you're all going to say to me. Well, if they're young, we need to do it because they might have other kids. And I entirely accept that. But sometimes you just can't, because it's not about future kids. It's about that kid or those kids in these proceedings. Okay, so that's that side of things. In terms of evidence as well for legal to consider, I always find the police disclosure is very interesting because you get these logs of discussions they have, and it's, 1209 spoke to Mrs. Phone and she said that this happened. 1210 spoke to dad and he said this. 1211 spoke to mom, she changed her account, and you can miss that stuff because they write it in tiny little writing in the police disclosure. So I always spend hours going through like 100-page of police disclosure because there are certain things that you can snippet see. And if you do see it, you need to get statements from the officers who spoke at the time. Now, if you leave that to be put in the witness box, the judge might turn around and go, well, how do I know that officer hasn't recorded it incorrectly? It's hearsay evidence, Mr. Sword. And so what you need is you need to spot those things early. Go back to the police and say, which officer was this? Can you give us a statement of the account he took from mum? And that's why I say, have a look at that. Statements and logs are very important. Remember the relevant statements. So sometimes what people do is they see the officer takes a statement from the neighbour, for instance, and they think, well, that's our evidence. No, you need to go to that neighbour and get them to do an identical statement, but in a Children Act version. That's all you need to do to make it primary evidence, but you still need to do that. So don't assume that the police statements become primary evidence. They don't. Golden nuggets in police interviews. So I recently had a case where this baby's had a really nasty brain injury, and it can either be from someone hitting the child, or it can be from someone dropping the child. And all the way through, of course, I'm pursuing hitting the child. But then in police interview, I saw that dad mentioned that mum might have dropped the child at one point. And I thought, oh, because actually that's what the medical evidence suggests. So I had to go back to the experts to ask about that scenario. Thankfully, they came back and said no. But be conscious of that, because there are certain nuggets in police interviews that might help your case, or it may mean that you've got to withdraw, and it's better to spot it sooner and deal with it than have it come up later and find you've wasted a lot of time and resources looking at exploring and pursuing a case against someone when the answer was obvious. I've written there, remember to advise social workers on the importance of taking allegations from children. Now, you should all have attended my seminar a few weeks ago on taking allegations from children, best practice rules, etc. And I gave a handout. What I would like you to do moving forward, if you can, or my tip for you is, send that handout to every social worker that comes to you with children who are of a certain age so they can speak out in these types of cases. Because you know as well as I do, when children go into foster care, they talk, and you want that handout and the best practice guidance to go to the social worker, to go to the school, to go to the foster carers, so that if the children do say anything that can help your case, A, you notify legal very quickly, and B, legal have made sure that you've done everything you can by way of advice to make sure that the evidence is gathered in a way that is safe and not contaminated. And remember to piece the events together. As I say, make a chronology and patterns will emerge. And that is, to me, that is what I do in these cases to start to build a case. Okay, final section, reviewing the term non-accidental injuries. Now, someone at the session before said to me, should you really be saying non-accidental injuries? The answer is no. But to be honest with you, you all knew what I meant when I set up the heading of the seminar, and it's still a term that's widely used now. So when they said it to me, I thought, oh no, I really shouldn't have called it that. But it's here. The case is Re-S A Child 2014, or one of the cases. The term non-accidentally injury may be a term of art used by clinicians, and I make no criticism of it, but it is a catch-all for everything. So what I tend to do when I draft schedule of allegations or threshold is, it's hard, isn't it? Because you want to get it perfect to fit the medical evidence, but you also want to make a case against the parents. So I tend to copy the wording of how they've described the injury. So, you know, petechiae bruising here, here, and here, and I'll spell out what they've described as the extent of the injury. And then I will go on to say something along the lines of exactly what they say. It's been caused by significant trauma that would have involved the use of excessive force. The person at the time, it was inflicted either deliberately or negligently, depending on what your evidence supports, by either mum or dad, for instance. The perpetrator would have known at the time that the force applied was excessive and seek timely medical attention, or something like that. So still you're wording from the experts, but you don't necessarily need to say it's not accidental injury. I think I tend to go for deliberately inflicted or negligently inflicted excessive force, which is what most of these medical reports come back and say to us. And that gets the point across. I mean, I'm sure somewhere someone will say, Reagan, you shouldn't be using the word inflicted. But, you know, you've got to describe it somehow, haven't you? And judges tend to know what you mean, and they tend to use that wording. And besides, when you start these cases at the finding of fact hearing, you don't tend to know if it was a slap or a kick or something like that. You tend to maybe find that out as the hearing progresses, so that at the end you can revise your threshold to say it was excessive force by way of a slap. And then I don't need to do inflicted anymore. I could use more specific what the infliction was. But that's how I would draft it and try to follow that pattern rather than calling it an AI. So there we have covered the law and interveners, which I missed out for you last time, some guidance on when we go to court, the approach to take in the interim in terms of placement and contact. We have also covered what social workers can do to gather evidence to help. And we've covered the kind of things that legal need to be advising on and looking out for when these cases are going through the process and you're gathering information from the social workers. And finally, why you shouldn't use the term non-accidental injury. Thank you all for listening. Does anyone have any questions? I can't see any questions coming through. No questions. Thank you, Ravina. Okay, guys. Well, I hope that that was helpful to you all. If you do have any questions afterwards, by all means, feel free to email me. And by all means, keep the hand out. And thank you for attending. Have a good afternoon. I'll stay on the line anyway, in case anyone puts any questions in the chat. Okay, guys, thank you. Good. I think it's been helpful to a few people. Then I shall let you enjoy your afternoon.